are the pensioner matter, your lordship.
Yes.
And there is no date, further date showing in the computer, your lordship. Please list the matter.
This has to come in the hearing list, I suppose. You are talking about hearing list.
Yes, yes, your lordship.
Leave was granted.
Yes,
All right. Yeah, not recently. Yes.
and secondly, your lordship, please detect to my matter.
No, no detagging, etc. now. Not
Alright.
at the stage of mentioning. Yes.
May I please, my lordship?
You are
This-
there?
Yes, my lordship. In 802.
Yes.
Now, my lordship, this was that 138 matter where your lordships had asked me to move an application for stay upon deposit. I've already moved it. My lordship, I'd mentioned it. Your lordships had allowed the mentioning, but it was informed by the court master that, my lords, the unlisted mentionings couldn't be taken. Now I am under a listed mentioning. So some date, my lords, Monday or Friday, whatever your lordships please, my lords.
इसको लगा दीजिए, एक Monday को लगा दीजिए.
Very grateful.
Either this or the next one. All right. Yeah.
Very grateful. My lords.
I. Yes.
Grateful. My lords.
Please, your lordship.
Yes.
But three malus. Malus, this is a civil appeal malus for listing malus, for early listing malus. This is a landlord tenant malus, a short matter malus. If your lordship could give a date malus, early date malus.
No, this has to go to the hearing list, council.
Malus, this is for hearing malus. The leave has been already been granted by
Leave
your
was
lordship.
granted.
Yes, malus.
इसको भी लगा दीजिए hearing list में. Yes. All right.
Obliged.
Yes.
Obliged.
This is that fresh matter I mentioned yesterday.
Ah.
Then later I mentioned before Honorable the Chief Justice of India also at 2 p.m.
Right.
My lord said he would look into it. Now, perhaps that is why this mentioning, now this has come before your lordship, but it has come in 804. My problem is, this is a
But
order of,
I think we'll wait for the order of the Chief Justice, Mr. Patwalia,
no,
because.
it's come only because of that.
Okay.
Only because of that this has
All
come.
right. All right.
Now, this is order of the High Court is of 8th of this month.
Yes.
9th we filed it, 10th it was cleared.
Yes.
11th it came as a fresh matter.
Right.
But because after lunch, the bench could not assemble on 11th, that collegium, etc. was there. So then it got out of the list. It was showing for today. Sunday night, then suddenly that today's date also went. So my problem is the rent controller will order my eviction today. So my lord, if it can be on Friday or Monday, and I can then mention that I have mentioned before your lordships and your lordship have given some fixed date, my lord. It's a fresh matter.
Fresh matter.
It's a fresh matter.
All right.
There on caveat, my lord, Mr. Huda's office is here. We have informed him yesterday.
All right.
Yesterday also he was there.
Lordship, this is the matter where your lordship is considering the validity, constitutional validity of the amendments to the Negotiable Instruments Act. Your lordship, by the order of 24th April, had directed Union of India to be impleaded and the learned AG to assist your lordships. Lordship, I'm appearing on behalf of the AG. The learned AG is in some difficulty today.
Yes.
We're requesting for some accommodation.
What I'm appearing is your lordship had been pleased to appoint me as amicus in the matter on 28th of August 2019. Learned AG had informed me on the last occasion I've handed over a copy of written submissions and I've conveyed a copy also to the AG's office.
I am appearing on behalf of respondent number 1, Axis Bank in this matter.
So very well. So AG is appearing on behalf of the Union of India, right?
Yes.
But that's your lordship's
That's
previous order, Lord.
Yes.
On 24th of April, keeping in view, not there was an issue of interpretation and interplay of
No, no,
142A
correct. It's
with
all
your
right.
lordship's transfer powers.
All right. Union of India was included as a party considering the legal issues involved. And we are informed by Ms.
Amey Vikrama Thanvi.
M.A. Vikrama, Learned Counsel, that the Attorney General, Learned Attorney General is to assist the court, but he has some difficulty to do stuff. Accordingly, as prayed for, the matter stands deferred by stop. As a Mr. Siddharth Rutra, Learned Senior Counsel, who is appointed as the amicus, submits that his written submissions have been already filed. Stop. Noting the request from the side of the Learned Attorney General, the matter stands deferred by 3 weeks. Yes, next.
Lord, may I just on item number 1 only? I have filed one intervention application, my lord, as the lordship is dealing with the effect of 142A on the complaint filed under 1.
This is just a transfer application. You don't have to be. Yes, next.
Is your lordship,
Any date?
any fixed date that your lordship?
No, we are not fixing any date. Yes, next.
Grateful, your lordship.
It's a 2018 matter. It should ideally go for the hearing. That is how I am looking at it. Yes,
Grateful,
next.
lordship.
Yes.
Because, after your lordship's previous orders, we had been pleased to implead the respondents 3 and 4, who are the officers, my lord, in Haryana, who now freely confess on affidavit their own role in holding joint immovable property, not once but repeatedly, with the complainant. And this is where the complainant goes forum shopping. FIR registered in UP, FIR registered in Delhi, FIR registered in Rajasthan, FIR in Gurgaon, just meant to harass me. And your lordship may see that first order, where your lordship recorded the entire facts, 4th December 23. There's nothing in this matter. It's just a brother wanting to harass his brother. There's a loan taken, the loan is fully paid off, then bad blood between brothers, and he says at that time that the loan was sought for, my signature was forged on that document.
It's in the 4th December order. Yes. 4th December. See.
If your lordship kindly sees the impugned order at para 5, please see the detailed allegations. This has been oversimplified to say it's just a sibling dispute. There are clear-cut allegations of forgery, and the FSL report proves prima facie that there is forgery. There is a statement of a material witness saying that I was never a party to this signature that has been done.
You are appearing for this state?
I beg to appear for the respondent number 2, I am the
No,
FIR informant.
Okay, you are appearing.
So I'm just inviting my lord's attention to the impugned order, what's there in the impugned order. If your lordship kindly sees para 5, these are the detailed allegations in the impugned order which led to the dismissal of his application. It is submitted by the learned counsel of the state and the counsel for the complainant that there are specific allegations where the petitioner for number 1, forgery of signatures of the complainant on various documents, number 2, forgery of signatures of the father of the complainant, number 3, transfer of shares of the complainant in the name of the petitioners. And the police had not straightaway recorded the FIR. Rather, before that, an exercise in the nature of preliminary inquiry was conducted, and the signatures on the disputed documents were got compared with the signatures of the complainant from the Forensic Science Laboratory, Bouncy. However, the report of the said FSL has substantiated the allegations of the complainant that the signatures on the said documents were not the signatures of the complainant. Even the signatures of the father of the complainant on the disputed documents were got compared with the admitted signatures available in the bank account of the father of the complainant. FSL reported that even the said signatures of the father were forged. It is only thereafter that the FIR in question was registered by the police. Case involves huge fraud of 80 crores rupees. The investigation is at an initial stage. Police are to unearth the true dimensions involvement of the petitioner in the crime. Yes. Therefore, custodial interrogation is imperative.
Yes.
And therefore, subsequently, based on that, towards the end, the application was dismissed. Yes. So therefore, these are the prima facie material that has come on record.
Right.
The lordships have to then, in my respective submission, based on all this, it's not my saying, it's the FSL saying that the signatures are fraud.
All right. What does the state wish to say?
I
I feel, my lord, this is a case, my lord, where this gentleman has not only been doing it for the first time, my lord. The petitioner is involved in other FIRs also, my lord. In fact, my lord, I have given a comprehensive affidavit, my lord. The investigation is almost complete, my lord. We have been able to get all the documents, my lord, which shows that he has been forging, my lord, signatures of his father, forging signatures of his brother. Father is no more, my lord. Shares worth 80 crores have been transferred by him in his favor, my lord. And my lord, I will, my lord, show that while he was called for questioning after the protection was granted by this honorable court, my lord, he came and, my lord, he has been making evasive statements, my lord. I will produce those statements also.
Whatever
I
said in
have
your,
annexed.
specifically in your counter, if we may just have a look at.
Yes, my
glance
lord.
at it just.
Yes, my lord. May I request my lords to have my counter, my lord?
Para page.
Yes, my lord. My affidavit starts at page 260, my lord. And my lord, my preliminary submissions
Relevant record.
shows, my lord, his involvement. I will start from para 7, my lord, which is on page 263, my lord. That the admitted signatures, my lords have it. My lord, para 7 of my counter affidavit on page 263, my lord.
You've gone back.
263, my lord, of state's counter affidavit.
Yes, yes, para 7.
Yes,
Admitted
ma'am.
signature.
Yes, ma'am. That the admitted signatures of Sri Ratan Chand Bairathi, father of the complainant, were obtained from ICICI Bank Sardar Patel Marg, Jaipur on 16/6/2023 after serving a notice under section 91 CRPC. The admitted signatures of the complainant Rajiv Bairathi and his account opening form were obtained from ICICI Bank DLF Gurugram after serving notice. Then, not few lines down, the questioned signatures of the complainant and his father upon the documents obtained from Neogrowth Credit Limited and their admitted signatures obtained from the concerned banks were sent to Regional Forensic Laboratory, Bhonsi. However, the same were returned by RFSL with certain objections. Then the bank locker form of Shri Ratan Chand Bairathi was obtained from ICICI Bank, Jaipur on so and so, and the original copies of checks number so and so of the complaint were obtained from State Bank of India, Sushant Loh. The above mentioned documents were again sent to RFSL Bhonsi for comparison with the specimen signature of the complainant. The report was received from RFSL Bhonsi on 14/8/2023, and as per the said report, the questioned signatures and handwriting did not match with the admitted and specimen signature handwriting obtained from bank. Since it was proven through FSL that the documents used for obtaining. Now, this is only with regard to the loan, my lord. I will go on the share thing also, my lord. Now, please come on para 9, my lord. My lord, we summoned the officer of the NBFC who granted this loan, my lord. He also comes and says that I was handed over the signed documents by the accused, my lord, and he has filled the form also, my lord. He said only signatures was left so that he can get them done. He came after some time, handed over the documents and then submitted the signatures. Now, my lord, we also, under section 91, my lord, when he was questioned, we asked him that you please provide us this loan agreement. He handed us over the loan agreement minus, my lord, the documents on which signatures were there. When the signatures were obtained from the NBFC directly, my lord, we confronted him and he started giving, my lord, evasive replies, my lord. Now, further, my lord, if my lords will see, my lord, kindly see, my lord, how, my lord, he is answering the questions, my lord. Kindly come on page 268, my lord.
Para?
Page 268, my lord.
Yes, yes.
268, my lord, para 3. My lord, we asked him that who has applied for this loan, that the petitioner did not approach or provided loan KYC documents to Neogrowth. He says, my lord, it is denied by Neogrowth official Harmeet Singh, who in his statement claimed that only the petitioner himself was involved from initiation to disbursal of loan to Sai Future, including submission of filled in loan documents and KYC. Then, my lord, next para that the petitioner.
No, it's all right. Yes, we have got a flavor of what you are trying to say.
Now, my lord,
Yes.
if I can understand, my lord, it is a trick which normally, my lord, we lawyers play in the trial court, that you look, these officers are involved. These officers at their behest, this FIR has been registered. Now, my lord, the lady officer, she is a President Medal awardee, my lord, and she is a very senior officer. What she has disclosed in her property returns, my lord, on the portal of the IPS officers, my lord, from there, my lord, they are getting this document and saying, look, she is doing some sort of business with him. Now, my lord, admittedly, she is a family friend of both the brothers, my lord. She was knowing the family, the mother, father, and a number of times she tried to intervene and sort it out also. Ultimately, she said, okay, if you want to fight, I don't want to be a party. My lord, I feel, my lord, unnecessary, my lord, on the first date, when they have taken this notice, my lord, they have misled this court, my lord, by making the court believe that some officer has helped in getting this FIR registered, my lord. What about those other FIRs which my learned friend has himself pointed out in UP, in Rajasthan, and in Delhi also, my lord?
Yes.
And everywhere, my lord, the investigation is at an advanced stage, my lord.
All right, yes,
Yes, my lord.
yes.
Manoj.
Anyone else? I think that's, yes, Mr. Gopal.
I just want to give you some dates, Manoj, which is what led to the initial order where you gave us protection as well. This,
Thereafter, they have only obtained, my lord, adjournments, nothing else,
We
my
have
lord.
read
8,
your-
6,
we have
7,
read
8
your
months.
Initial order, which contains
Yes.
the
the
details.
Lordships have read that.
Yes.
Now, this loan agreement is obtained on 30th October 2017. It's a loan agreement, 30th October 2017, Manoj.
Yes, yes. we know
It
that.
is for an amount of 25.75 lakh.
Lakhs.
And both the Bharati brothers as well as the father, they're all mentioned as borrowers. What is significant is not one FSL report says that I was responsible. It says that the signatures do not tally as per their investigation.
Yes.
Now, this loan is sanctioned in December 2017. It's a 1-year term loan. It's fully paid out on 5th January 2019.
Yes, yes.
After being fully paid out, my client writes to the complainant and tells him that, look, this was the amount that we have taken as loan. This is the amount that has been paid off and it is accepted. There is no demur. He doesn't say, how did you get my signature? How did you get a loan for this amount? How did you repay this loan? It's entirely done by the company. There is no demur, my lords. This is in January 2020. From then, there is absolute silence. The father passes away, and then, as is the custom in these situations, my lords, the shares which had been transferred as a gift from the father to me, these are the two issues. One is apparent forgery on a loan application where the loan has been fully paid off. The second is the share transfer from the father to me. That share transfer, the mother files an affidavit. Our common mother files an affidavit. Your lordships will find that in my IA. It's at page 75. It's dated 22nd June 2021, where she swears that this transfer which had been done by her husband and her, that was genuine and by free will. And she specifically says my elder son is harassing my younger son and trying to make out some sort of case here when it's clear that the shares have been transferred. The elder son complainant then leaves the company. He resigns from the company and goes. After going away from the company, his first complaint is filed in Gurgaon in December 2022. A full 2 years later, after that loan has been paid off. And that is the present FIR out of which this arises. It is registered in February 2023.
Yes.
Now, the reasons why we had reservations about the police in Gurgaon is about what transpired thereafter. The mother, I do not know this police officer at all. I have never known her. I've said it on affidavit. So to say that admittedly our family knows, our family doesn't know, we never knew. Rajiv Bharati, who is the complainant, knows this police officer, and the police officer's affidavit now surprisingly admits that she and Rajiv Bharati had common investments in properties in Gurgaon. They used to buy and sell properties, not one, but 4 different properties which are jointly held in their names. I admit it is stated in her IPRs,
Yes.
but this is there throughout with properties in Gurgaon. She is the additional Director General of Police. And you go for facts which don't involve Gurgaon, you go to Gurgaon, register an FIR, and my lords, there is an employee of mine who is summoned by the police there, beaten up. That person writes a letter to the Chief Minister saying, look, I've been beaten up, I've been forced to try and give a statement, trying to in some way lay accusations against me. He withdraws that he goes back a second time accompanied by a lawyer. The lawyer is asked to wait outside. He's beaten up a second time, which is what led to us having an apprehension regarding the police there. Now, if matters were left there, my lords, and looking at the FSL report, etc., once we have to respond to only that, it may be something. But what happens thereafter is even stranger. On the same facts, by the same complainant and his wife. My friend should have been fair enough to say that when he was talking about the other FIRs. These are not some unconnected FIRs. Same Rajiv Bharati, my elder brother, goes to Jaipur, registers an FIR. Goes to Noida, registers an FIR. Comes to Delhi, registers an FIR. All on the same facts. Entirely same facts, again and again and again, meant only to harass me. As a result of which, Manoj, I have at page 99 of my application, IA number, which is for additional documents, if your lordship will kindly see. This is IA 239332, if your lordship will kindly have that. I'm an upstanding businessman. I'm having a company to run. I mean, whatever.
It's all right, Mr.
Yes.
Sharma. We have this thing. You don't have to give compliments to yourself.
No, I'm just saying, I agree, my lord. But it's this kind of sad situation where family turns against family and I have to be defending myself in 4 different states.
This is not unusual. I mean, let's not.
Yes. Now, every single document that has been asked for has been sent to the state. Every single document. And I have with me, my lords.
Right. We have got this thing.
I just want to say one small thing.
Yes.
One small thing.
He is making
One small thing.
allegations.
Just a minute.
Allow me to complete.
That should not be this.
I'm
sorry.
I want to show your lordships. We have couriered every single information that he asked for, KYC documents, loan agreements, everything. Every single one of them are sent back by the investigating officer
all right.
saying will not receive. Every single one. I was showing you from that IA, my lords. If your lordships will
No,
see.
no, we are with the IA. I mean,
Just see page 99 for a minute, if they've handed it up.
All FIRs are by the brother.
I know, I mentioned. All affairs are by the brother and his wife.
One immediately after the court order. My lord, may I have your lordship's liberty to just take five minutes, my lord, not more than 5.
no, Mr. Gopal has done a commendable job, Mr. Rohit.
I know.
My job is never commendable in comparison to the giant
Not-
that is Mr. Rohit.
We would not like to have 2 commendable jobs.
Very well.
Yes.
Manoj will take page 99 of that IA. Manoj.
Yes, what are you saying?
Now, just see page 99 for a minute. Your lordships have that list of complaints. Now, if you see each one of them are complaints filed by either Rajiv Bharati or his wife, Malad.
No, correct.
NCLT
these are the
cases,
complaints by
criminal
the-
cases.
by the elder brother.
Yes. Now, please note all the way up till item number 8. Now, this is significant. On 4th December 2023, my lords, your lordships were pleased to pass an order granting us that protection and asking us to implead the respondents 3 and 4.
Yes.
Immediately after that, that's not here in this chart, on 16th March, one more FIR is filed by them in Gurgaon and it's registered on the same facts. This shows the kind of regard they have for the court's protection given to us.
All right, yes.
There's civil litigation on the same facts,
that's
NCLT and CL.
Now, we are just asking you this question.
Yes,
We are proposing to dismiss it. You want us to dismiss it with elaborate reasons, or you want us to dismiss it simpliciter? Because if we record reasons why we are dismissing it, that might cause prejudice to you. But we are prepared to record our reasons.
Of course.
but that will prejudice us in
No,
other
that's
cases.
what we are, that's why we are saying. We have indicated what we are proposing to do.
Very
And
well.
then we are saying that this is what we intend to do.
Lord, we'll withdraw. We would not like. Lord, it's a case of vendetta between.
No, correct. That option is also, they want to withdraw.
Lord, it's a,
All right, that might be a better, strategically better option.
it's actually a case of vendetta.
No, that's okay. I mean, we are thinking that it may not be a case for us to entertain and anticipate. it.
Lord, may I
All
only,
right,
only add one feature which your lordship might recall.
let us not do that.
Just one feature. The lordships allowed me to add that police officer. That police officer is on record saying, Milord, that they have business dealings with this party, and that is why every FIR is in Gurgaon, while the company, Milord, is not in Gurgaon, it's in Noida or Jaipur.
You see, argument of Mr. Rodgi is so persuasive, we might say that we have to dismiss it academic session. For the next three academic
Yes,
sessions.
24, 25,
Maybe
page
25,
12, my lord, prayer.
24,
24, 25, 26,
26, 27.
and 26, 27.
28. वो prayer में देख लीजिएगा. In terms of section 33 of the Mahatma Gandhi University of Medical Sciences and Technology from Jaipur Act 2011 stuff. This para, the above order, would be subject to the final outcome of the special effect stuff. ठीक है? ये आप देख लीजिए पैरा 16 पेज 16 में है आइए का और प्रेयर देख लीजिएगा वहां से. Yes.
Deeply obliged. Deeply obliged.
Please, Lordship.
Yes.
Lordship, this arises out of a judgment of the Guwahati High Court, Lordship. Lordship would see here the first round, this is the second round, Lordship. In the first round, the prayer for regularization was dismissed, Lordship. They came up in a SLP, that SLP was also dismissed. So, Lordship, so far as the regularization part is concerned, Lordship, that is concluded. And now, Lordship, thereafter, Lordship, there was an amicable settlement.
Yes. What is wrong with that? Yes, yes.
There are two parts to it, Lordship. One, the second round, what happened, Lordship, when the matter came before your Lordship in 2013, Lordship sent it back. Lordship dismissed the SLP, but only on the point of pay equality, Lordship had sent it back. Thereafter, Lordship, in a review petition they went, and in the review petition, Lordship, there was an amicable settlement.
Oh, that's okay. That's past history now. Well, the impugned judgment of the division bench, of course, single bench upheld the rejection.
Yes, Lordship.
Let's have a look at the reasoning of the division bench.
The division bench, Lordship, I would only for present, Lordship, would concentrate at para number 15 of the judgment.
14 also.
That is, Lordship, on the allowances part.
Please read
What,
14
Lordship?
also.
Yes, Lordship, I'll read 14. It is also not in dispute that those from the petitioners who are holding grade 4 posts have already been extended the benefit of minimum pay scale as well as allowances attached thereto by virtue of the state government's notification dated so and so. Hence, excluding the remaining petitioners from the service of serving against grade 3 and denying them the benefit of allowances attached to the minimum pay scale would be nothing short of hostile discrimination and clearly violative of the fundamental rights, Lordship. That is on the part of, Lordship, I am presently harping on and for pressing for your Lordship's consideration the part of pension. So far as the pension is concerned, Lordship, the Guwahati High Court said that you go and make a representation and the state will decide by a speaking order. We did decide by a speaking order and rejected it, Lordship. Now, Lordship would kindly read para number 15. There is absolutely no discussion on that part in the entire judgment, but what the High Court says in para 15, as a consequence of the appeal deserves to be accepted, the impugned judgment 21/9/2021 reserved, and as a consequence, the speaking order is set aside, Lordship, without any discussion, Lordship, on the entire judgment. Lordship, have read the judgment, Lordship. The 7-page judgment has only this one line that the speaking order that we passed on the pension aspect has also been set aside without any consideration, Lordship. And the single judge decided in our favor.
Very well.
Lordship, at least on this part, Lordship, this consideration, Lordship, needs to be done, Lordship, because Lordship would see the rules does not, Lordship would now come to the speaking order at page 144. What we decided in page 144, Lordship.
Yes.
May I read the speaking order, Lordship? This is what the Lordship, the High Court had in the earlier judgment. If Lordship what the 2017 judgment also I can take where Lordship the High Court specifically said that you will make a representation and the state will decide by a speaking order. So, Lordship, I am reading the third para, Lordship, of that order. It may be mentioned, Lordship, in para 144, page 144. It may be mentioned herein that since the petitioners are not regular employees, and that, Lordship, is decided by your Lordships, up till your Lordship. The judicial department was not in a position to extend the benefit of pension as well as medical benefits to the petitioner.
and ordered it in a Ganeshan Madras High Court, granted the full pension. And a full pension was granted to me, and by a letter dated page 17. They started giving me full pension. I said the full pension, the computation is not correct. The computation has to be according to my pay scales given therein. I made a representation. Tribunal dismissed it. High Court dismissed mainly on one ground. It said that since you superannuated in 2006, therefore it is a very belated claim. At page 4, Lordship, at bottom. Belatedly, he was superannuated.
Yes.
Now this, in Tarsem Ali, this court has said, Tarsem Singh, sorry. May I just pass a compilation, Lordship, because it's a, नहीं मेरे वाला कहाँ है? मेरे वाला चाहिए था, ठीक है.
No, so when was the claim first made? You made, as you said, you retired in 2006.
6, Lordship.
And
And at that time, they were giving me 1/3 pension only.
No.
1/3 only.
correct.
1/3. Thereafter, my full pension came by way of Ganeshan's order. I given a compilation where the orders are also there. That's a legal position is not in dispute.
Is the compilation already filed or what?
No, no, this is it's compilation of rulings. I'm just passing it, Lordship, if possible. The full. One second. A chart, which is I given a chart. Because it goes and that's what the parity would be required. That's the only short.
We are not having any chart.
Lordship.
We are not having any chart in 16.
Page 16 of SLP. SLP, sorry. SLP, not in the compilation. Lordship.
This appendix.
16. My appointment was AME, Assistant Mining Engineer. Third pay commission gave me 650, 1200. Lordship, third pay commission gave me 500, 650, 1200.
No. Just a minute. This mining engineer is not here. Assistant mining engineer is
Lordship,
part of the assistant chemist, mineral officer, etc.
GSI, Assistant Mining Officer, IBM. That's the IBM heading.
Yes.
IBM, Indian Bureau of Mines.
Yes.
GSI is Geological Survey of India. First is Assistant Mining Geologist. Second is Assistant Chemist. Third is Mineral Officer. I'm Assisting Mining Officer. These are all class B gazetted posts. In third CPC, if the chart, it gives 650, 1200. And when in fourth pay commission, it has got a computation of 2000, 3000.
No, you can't be speaking like that, claiming like that.
Lordship.
You see, at the time when you had superannuated,
Lordship.
what was the pay that was being paid to you? Please tell us that. Don't talk about third, fourth pay.
You are asking for equating the post.
That's what precisely is a point which I may like to make because it's a computation and I have been non-suited.
Your only ground, as could be seen from the order of the Central Administrative Tribunal, is you are asking for 4th, 5th and 7th pay commission posts to be equated to your post.
Lordship.
Can that be done?
Lordship, two reasons. That's absolutely. That's a short point. That's an uphill task. If I am able to make out a case, therefore, computation of pension only. I can't be shunted out on because I was in superannuated earlier and I have not come in because pension is a continuing cause of action.
Can't be, I mean, Council, it will be very, very wrong for us to say that now you recompute the post that you are supposed to be holding because you retired in so-and-so post. And then thereafter to grant you, fix your pay scale at a higher level and then grant you proportionate higher pension on that basis. It will be.
Lordship, it has to be computed. It has to be computed in accordance with that. And that's why I given a page 16. That's a comparison. And that's a.
No. That cannot be. We are, brother, I don't think this cannot be done now.
May respectfully submit. I foresee what this 4th pay commission has given me that salary of 2,300, 3,500. And at the bottom, just see the GSI. The lower post was also given the 2,000 and 3,500. I am being given a lower grade.
The equivalence is not the job of the courts. It is they are the expert of experts. They will do it.
I go just one line. We go with the recent judgment of this court. Recent judgment court. Compilation of concept, which is at page 5665.
No, this assuming for a moment's sake, we'll accept your contention.
Lordship.
This equivalence, you knew when you were drawing 1/3 pay, 1/3 pension. Why did you not raise it? On the ground of laches and delay, you have to be non-suited.
Lordship, as far as the laches and delay part is concerned, Tarsem Singh is specifically very clear on this place because as far as the pension part is concerned, pension is a continuous wrong. Monthly, and it's a continuous cause of action.
But you cannot go into coma and suddenly wake up.
No, not suddenly. It gave to me.
You knew what was your pay band or pay scale when 1/3 pension was granted to you.
I was granted for the first time the full pension after
irrespective of the quantum of pension, you knew the pay scale
on which the computation would be made.
You are fixed.
On which the computation
can be made. Asking that pay scale itself to be changed.
No, Lordship, that's the only thing which I just need one paragraph of this judgment.
You are asking us that the court should have done rather.
Lordship.
That should make the post, your post, that post that you held should be considered as equivalent to this post, and that we are unable to agree, Mr. Sharma. That cannot be a basis for
just one line, and thereafter I would see with the compilation which has given this the recent judgment. It is a page judgment begins at 25, 26. It begins. Compilation.
Yes.
Union of India versus DGOF Employees Association. This also had the same similar pay parity at Part Z, and I would come straightway to para 10, which is given in, if I made out a case that it will begin internal page 48. That's compilation which I have given. The judgment begins at page 26.
You may read that. We have quickly read it, of course.
I read para 10. I straightway come to that because it was A cumulative perusal of the opinion expressed by this court would indicate that though the courts would not undertake the exercise of determining the pay scales, keeping in view the nature of the work by comparing employees who are not similarly placed in cases where the exercise of determining such complex issues would arise. At the same time, the relief cannot be denied to employees when the entitlement is denied due to irrational consideration without application of mind to the facts involved in the case by the employer, thereby denying the benefits to the employees. Now, my respectful submission in this regard is, which I have given a chart. Okay.
Yes, yes.
The chart, I come again to the page 16.
We've seen that, Mr. Sharma. Yes, anyone else?
Well, it's-
Anyone?
Well, I have 4 points,
Yeah.
but I think to answer my learned friend, and I'll take my loss to why he's not entitled to a number of issues. But Malas will come to page 11 of my counter, para 19. And I'll take Malas through my other submissions as well subsequently. But this entire question with Lordship is said at back calculation. It is humbly submitted, para 19 minutes. It is humbly submitted that the recommendations of the Fourth Pay Commission were implemented. My lords are with me on that. From 1/1/86, whereas the petitioner was permanently absorbed in IBP, Indo-Burma Petroleum, with effect from 82 forenoon. Thus, the petitioner was not a serving central government servant on the date of implementation of the Fourth Pay Commission. It is further submitted that the case would be covered by the recommendations successive made for the pensioners. The claim of the petitioner of a higher notional pay scale for the assistant mining unsustainable. He was not a serving government servant. So he can't enjoy both. He gets into a PSU, Indo-Burma Petroleum, and then claims this as well. Then, I have another submission. We'll come to page 4 of my counter. As to what was the nature of his appointment, that assistant engineer which he's claiming. My lords, will start from page 3, para 7. The petitioner was appointed to the post of junior technical assistant in the respondent number 2, Indian Bureau of Mines, with a pay scale with effect from so-and-so forenoon. He was subsequently promoted to the post of senior technical assistant mining engineer to the scale of so-and-so 325. He was again promoted to the post of senior technical assistant mining engineer selection grade in the pay scale from so-and-so from 1/4. He was appointed then, Malats, this is the crux. He was appointed purely on an ad hoc basis as assistant controller mines for a period of 6 months. From 22/12/1978, the ad hoc appointment to the post of assistant controller mines did not confer any right on the petitioner for the regular.
Mr. Man, you're all right. We are not entertaining. You don't have to labor harder. All right. Heard Mr. Sharma. Yeah, Sharma, senior counsel appearing for the petitioner. Stop. The respondents are represented by Mr. Vikram Banerjee, the London Distance of Citizen of India. Stop. The claim here is to grant for the petitioner who superannuated in the year 2006 higher pension than what he is currently receiving. Stop. The non-counsel would refer to the judgment of this court. यहाँ पे जो page 26 में है उसका details दे दीजिए. To say that, to argue that although the courts would not undertake the exercise of determining the pay scale, keeping in view the nature of the work by comparing employees who are not similarly placed in cases where the exercise of determining such complex issue would arise, at the same time, the relief can be considered for employees when the entitlement is denied due to irrational consideration. Stop. On the above contention, we may observe, we may refer to the counter affidavit On the above contention, we may refer to the counter affidavit filed by the respondent, which indicates the service record of the petitioner, and more particularly the fact that at a given point of time, did he go on deputation?
He was
He went on deputation to which organization?
IBP. He was absolved, my lords.
Petrol.
Petroleum, page 11, my lords.
Page 11.
Indo-Burma Petroleum, IBP.
Indo-Burma Petroleum, IBP. Stop. But in any case,
He was absolved.
the pension is ultimately determined on the basis of the last pay drawn. And it is nobody's case that the pension that is being remitted to the petitioner is on the basis of the said last pay drawn by the employee staff. This court, in our understanding, in our opinion, this court should not undertake an exercise of equating the petitioner's post at the time of retirement to other posts and relate them to the benefits of the subsequent pay commissions stuff. The view taken by the High Court, not only on in the impugned judgment, not only on merit but also on the ground of late claim preferred by the petitioner, cannot be faulted. Stop. The SLP is dismissed.
Obliged. Deeply.
Deeply obliged.
Yes, right. We granted courtesy.
This was a reversal in first appeal by the High Court. Today, my lords, there is an application for substitution of R1, for bringing on record the legal heirs of R1, my lords, that I have filed.
R1 has died.
R1 has died, my lords.
That is Anjaya.
That's right. But may I just indicate there's a delay of 1,228 delays. It was their appeal, the trial court decreed my suit, my lords. The respondent's appeal in the High Court and the first appellant in the High Court died pending appeal. Technically, the judgment must go because the appeal abated even before the judgment came.
So when the appeal was pending before the High Court,
He died. Just 3 days, my lords. Trial court decree is dated 15th March 2018. 15th March 2018 trial court decree in my favor. Their appeal, my lords, filed in 2018. He died on 21st October 2010. Appellant number 1 before the High Court. 2020. 20th October 2020.
20th October 2020.
And the impugned order is passed, reversing the decree in his favor, my lords, on 10th February 2023. My lords, after your lordships issued notice, my lords, in February 24, your lordships office report, this court's office report indicated when they tried serving them that he has passed away. So we applied, my lord, that's the delay. But technically the appeal abates. Respondent number 1's appeal in the High Court now abates.
Lord, I am appearing for respondent number 3. So I still have to file my counter affidavit.
That 3 times they sought time, my lord, but nothing.
So far as this particular person is concerned,
With respect to respondent number 1, my lord, I have only instruction to say that because I am not appearing for respondent number 1. That's the problem.
but in any case, notice may have to go.
I'll also leave this question because I want to agitate this matter. I'll also leave this question open so that I can urge this. They are brothers, all of them, my lords.
What is the IA number? The
IA number 128085. 128086, 88 and 90. 4 IAs.
These IAs have been filed on account of the passing away of the respondent of Anjaya within bracket defendant number 1 on 2010-2020. Stop. Mr. Parmeshwar, Learned Counsel would point out that the decree in favor of the plaintiff in the title suit 20 of 2010 was rendered on 15/3/2018. And although the defendant number 1 died on 20/10/2020, the High Court by its judgment dated, by the impugned judgment dated 10/2/2023, allowed the defendant's appeal and dismissed the suit filed by the petitioner. Stuff. The High Court was unaware.
High Court was unaware.
The High Court was unaware about the death of the appellant at that point of time. Stop. The application, the LRs, the application for substitution of LR is also supported with other applications for setting aside the amendment and condonation of delay, etc. Stuff. Issue notice, returnable in 4 weeks. Stuff. The which respondent?
Respondent number 3.
Mr. Swenson, non-counsel appears for the respondent number 3. You are defendant number 5.
I am defendant number 5, my lord, before.
Defendant number 5. So the counsel pays for and is granted 4 weeks time to file response in the matter.
This is the third time in Lotus week. Third time they have sought time.
We've granted them for the 3rd time.
Yeah.
I'm so like,
Why you are not filing the? You are not,
Lord, I will file
you are a
it.
little shy or something? I mean, your client. I'm not saying you.
Lord, I will. Lord, this time we will file, Lord. It's a complex matter, and because some local council is also involved, who is going to assist us.
Just do that. You should not hear this kind of comments, right? Avoid that.
Gather all instructions.
Please.
That's a loaded statement.
Grateful.
Yes.
Grateful.
Before my friend starts, I
controversy
have
here.
one small submission that by way of your order of 29th January 2024, your lordships had been pleased to at the interim direct for the appointment of
Let me open the case.
9,000.
He is not even a respondent.
9,000. I'm respondent
So,
1.
he-
9,533 candidates, which includes me. Now that was with a caveat there, the rider, that it should be stated in clear terms that the appointments made shall be subject to the outcome of the present petition. Now, Mr. Patwalia represents those.
So let me just open
Just
my case.
allow me to
This is
complete my
very
sentence.
unfortunate. My friend
I'm
does
just
it every
saying,
time.
I'm just saying that these 9,533, their appointments can be confirmed. Mr. Patwalia's will be filled up against the latter half if they are successful before your lordships. If they are not, then it will be the others who are below us who will get appointed. But if ours can be properly confirmed without the rider, that would be helpful. That's my preliminary submission. That's all I had to say.
This matter will have to be heard.
My lord,
as we can
just,
see.
this is the whole object is to deflect the hearing on merits.
No.
Every time my friend does it.
Not every time before this court, it's
No.
an ad hoc bench,
Yes,
so please
yes.
do not try to,
Yes.
this thing. We have other matters, so we are not going to take up this matter.
I have a very short request today. Please see the last
You
one.
make the request, yes.
Yes.
No,
In the-
don't ask us to see
All
anything,
right.
you make the request.
So we are people who qualified during the period 20.
You make the request, Mr.
Just
Patwali.
one line and then the request, because it has to be placed before that. We are people who qualified in the period 20 to 22.
Yes.
The single bench said we are eligible. Division bench says no, we are not eligible. Now, pre-20 are people who have all been appointed. 2,500 vacancies remain. Last time your lordship said, please declare our result and produce the list in court. So far, the list is not produced. May I just read that one line order, my lord? That is 15th May 24 order. List, and we have also given the interview. List the matter on 23rd July 24 on the, this is the order of 15th May.
Yeah.
List the matters on 23rd July.
May.
Pardon me?
Yes,
15th May. 15th May. Board had already filed an affidavit in the first matter.
Yeah. 41.
Somebody else was standing.
No, we have.
Order is there. On the said date, in addition to the affidavit which has already been filed by the board, list of persons mentioned in paragraph 14E of the affidavit dated 21st March shall also be kept ready.
Yes.
These are those 20 to 22 batch. The court found in an earlier order of 29 January, 11,000 vacancies were advertised. The pre-2020 are 9,500. 2,500 vacancies remain. We are less than 2,500. We are 950 before your lordships. In all, about 2,500. All of us can be accommodated.
Not eligible.
If the board points out whether we are qualified and suitable, then all of us can be accommodated. That is what I am saying, and there will be no surviving list. So at the moment we are only saying let this order be complied with.
No, the order passed to that effect. It's just said that
Just kindly see the 29 January order.
Let the order has been complied with, my lord.
Just see the 29 January order for a minute. That will clarify the position. 29th January. Please see the 29 January order. 29/1/24.
If they're not going to hear it.
In fact, the order, this matter was argued for paras 2 to 4, 3. Once your lordship gets the 29 January order. My lord.
He's listing them.
yes, it is there.
Can I just read it quickly? It's just 1.5 page. By order dated 22nd January 2024, the respondent West Bengal Board of Primary Education was directed to file an affidavit furnishing certain details relating to candidates. The said affidavit has been filed with copies furnished to learned counsel for the parties. As per the affidavit, 11,758 posts in various different subjects in various categories in all districts across the state of West Bengal were advertised for the post of assistant teacher for primary classes. After furnishing the details of the number of candidates who had applied in response to the advertisement, it has been averred that as per the draft list prepared by the respondents, 9,533 candidates qualify. This excludes us, which includes an additional panel of 5% candidates in accordance with the rules. It is also stated that a total of 2108 D.El.Ed candidates have been found not to be qualified amongst the pre-2020 batch list. It is further stated that D.El.Ed candidates from 20 to 22 course have not been considered in the draft list due to the issue pending in the present matters. That is us, having regard to the facts that as against 11,758 posts in different subjects in various categories in all districts in the state of West Bengal, the respondents have found only 9,533 eligible candidates, including additional panel of 5%. It is deemed appropriate to permit the respondents to declare the merit list with a rider. It should be stated in clear terms that appointments made shall be subject to the outcome of the present petitions. The letters of appointment to be issued to the successful candidates shall also specifically state that their appointments will be subject to outcome of the present petition. My instructions are that a total of 9,174 people have been appointed since. Now, para 4 is important for me today. The board shall conduct final interview and aptitude test for candidates from the 20 to 2022 course, that is us, and submit a report within 6 weeks from today with copies furnished to the other side. The remaining posts shall be kept vacant and are made subject to further orders that may be passed. So this is that list which your lordship said produce. Now, in their affidavit which they have filed, I need not read it, my lord. They have said that interviews have taken place. List of us.
Correct. You are considered to be non-eligible, non-qualified.
Yes, because the division bench judgment today stands against us.
So we can't be passing any direction for your appointment or consideration without going.
We are only saying, my lord, let us see how many of us have qualified, and then
we don't know, and we don't want to know at this stage.
My lord, at one stage, your lordship on the last date had said produce that list. But in any case, the issue is also very narrow. The issue is very, very. I can address it now, or. Your lordship, give us any convenient, when it is convenient, Lord. I don't want to push myself.
May I make a prayer? May I make there are some impediment application. Would you also consider issuing notice in them? They can come up next day.
We are contesting the impediments are
Without even
If I read one
getting a
application-
notice, he's already contesting without realizing what I'm praying
Reads
for.
That one application, your lordship will reject it just now. Your lordship may read, it's 1.5 page. I have not been able to make any sense of that application.
Very
Let us smile
He wants to
once
become a
again.
Let
petitioner.
the
Let
judges
us
do
all
their.
of us smile once again.
I have said my bit, my lord. I have nothing.
The board has that list, my lord. If that list can be produced, we will know where we stand, my lord. Is our only request, my lord.
Do everything that is to
Yes.
be done when we take up the matter for hearing, not in this fashion, right? Yes. Since this bench is an ad hoc bench, come on. The matter which would require some hearing cannot be taken up as many other matters are awaiting consideration. So the matter stands deferred by 3 weeks. Yes.
Grateful.
Your Lordship, consider issuing notice in the implement applications.
Rejected.
Oh, my Lord. No, that is not.
We have passed the order. After that, you are saying.
No, my Lord, I'm so sorry. I
I
thought,
thought you are pressing your application, so I passed an order.
my Lord, very sorry, my Lord. Please recall that order of rejection.
No, sorry. Yes, next.
Lord, kindly recall
No,
that
no,
order.
recall.
Not exactly. Kindly remove that order of
No,
rejection.
it's rejected.
Sorry, my Lord. It will not be there.
Leave with a smile. All right. वो नहीं रहेगा, rejected रहेगा.
Oh, my God.
My lord, this is a matter, my lord, where the sorry.
Yes.
Lord, this is a matter where the respondent, my lord, has been transferred from Southeastern Railway to East Coast Railway, my lord, and he has signed a letter that he will accept the bottom seniority. And there is a regulation, my lord, circular of the railway of 1977 that also indicate this thing, my lord. If, my lord, may I draw the attention of my lord, the order passed on, my lord, 6/9/2023. Order passed by this honorable court, my lord. Yes.
6/9/23.
My lord, may I read it, my lord? That will indicate complete case of the petitioner, my lord. Mr. Such and such would refer to the railway board's letter dated 3/12/1977.
That was supposed to go to the bottom of the.
Yes,
bottom
my
of
lord.
seniority. That's
That
right.
document
That's
is, my lord, that document is at page number 29.
Now, what happened? What is the impugned judgment of which is under challenge?
Arjun Singh, my lord.
No. What is the judgment under challenge? It's the
Yes, my lord.
railways which have challenged.
Yes, my lord. Impugned order say, my lord, the one Arjun Singh, where the Jabalpur bench of the tribunal has granted the relief in the identical issue, where we have challenged in the writ court, and the writ has been dismissed, and then we come to the Supreme Court, and the Supreme Court has also dismissed the SLP, but left the question of law open. My lord, on this point, my submission is this, my lord, that Arjun Singh case is distinguishable from this case, because Arjun Singh was in class B employee at that point. I'm sorry, my lord.
Operating in your favor, right?
Yes, my lord.
You consider the matter, there's nothing further to this thing. He's not got any benefit out of this because of the interim order, right?
Seniority list is all India seniority.
Sorry?
It has nothing to do with that particular undertaking that I had given at the time of
That's
transfer.
okay. There's an interim order operating in their favor and against you.
Against me,
right?
that's right.
So,
Therefore, my lord, urgency from my point of view, my lord, if
Understand
may hear it, it won't take more than 10 minutes, my lord.
10 minutes from your
I
side.
will-
Then we give 10 minutes to them. Then we are easygoing judges. We take a few minutes ourselves.
The entire idea was this, my lord. My lord, when
Don't expect, I mean, we have to just finish the list. There are all matters pending. Yes. We'll put it on this thing. SFPJ. The Learned Council refers to the order passed by this court on 6/9/2023. to say that the respondent is entitled to the bottommost seniority in the transferred railway zone, as it was a request transfer stuff. But this is contested by Mr. Bhatt, the SM Bhatt, the learned senior counsel appearing for the respondent stuff. To say should we grant leave and then we'll post it for hearing on a day?
My lord, this matter requires consider, my lord may grant leave.
No,
because
we'll
my
grant
lord-
leave. We'll grant leave. That's what. Leave granted. Stop. The interim order will continue. Stop. Matter be listed. एक आप date दे दीजिएगा in about 2 months' time. All right. Yes. Now there is an application for transposition or something.
No,
Is there an application for
My lord,
transposition?
yes, my lord. Some officers of the union, my lord, they have been made respondent, my lord. We have filed that application. That application, I
We
think-
don't need to pass it out. Right? Yes.
Just so your lordship knows, there 43 goes on to point 14.
40.
Item 43, which is called out now, goes up to point 14 statutory appeals. So for convenience, we made just one chart. Kindly hand it over to my.
We are not prepared to.
No, that's why I said so.
Take up the final hearing. This is a
Yes.
matter of which you know that.
That's why I said so in the
So,
beginning.
Milord, may I suggest, this matter is extremely urgent, but obviously, Milord, today it can't be taken up. Would your lordship post it at the earliest? It was being heard, Milord, regularly by court one on several dates, Milord, then somehow, Milord, it has appeared before this bench. So, Milord, I respectfully submit, your lordship.
To have a issue about somehow it appeared before.
No, not in the least, Milord. We are here every day, Milord, this court or that court. Would your lordship,
Can I say one more thing?
would your lordship, Milord, keep it at the earliest because
That earliest, we are not.
I have
that
no problem
earliest
any
business.
earliest.
We have other matters which we have listed of counsel who are present before this court today, right now, as of now. So therefore, you can't have an earliest, right?
Yes, my lord, we may be divided on everything else, but we are, I think, united in the request for early hearing.
We are actually overwhelmed by the united request.
It's a dangerous unity for your lordship's calendar. Well. Dangerous unity.
You also want to put in your bid, Mr. Tripathi? Yes.
we have debated the motion which you just produced, which we had.
But as far as the IBC matters are concerned, there is one substantial issue. And I'm not referring to documents. Whether in 31(4), is it only mandated or is the CCI approval required, but it can be required after COC approval? Matter is settled by your lordship's affirmation in appeal. That's the only question.
If such an united submission is made, we'll pass order straight away.
It can never be.
Unity has ended, my lord, at the request.
So therefore, your effort has gone to waste, Mr. Tripathi.
Now, let's one.
The only question is there's a direction that the successful resolution applicant should, my lord, hive off an additional business, which will happen after.
No, it's all right.
Can I make one more? Without any merit.
Professional, there's one request which needs to be considered between now and the next date, whenever that next date is. But there was an oral direction that the plan
There
approval
can
not.
be a consideration of request between now and the next date. It has to be considered only on the next date.
Your lordship may
So don't make that submission.
Your lordship may simply put a date.
The hearing, we want that for those proceedings not to go on because there was an oral direction not to go on with the plan.
A prayer for Mr. Courtmaster. A prayer for interim order is sought by so and so learned counsel. The prayer is declined.
Yes,
Is that what you want?
Please don't do that.
We are saying that we are not taking up.
Nobody, lordship, not hearing by.
Since you are pressing the matter, we have to
We will
pass.
do it on the next occasion.
Whatever date your lordship gives.
All right, the matter be deferred. Considering, how many matters you said?
14.
As 14 appeals are under consideration, and the parties are represented by different counsel. Substantial hearing would be necessary. Stop. The matter is deferred. These are appeal matters. Can we put it in the final hearing list?
Yes, I think
Yes.
so. Yeah, it would be
Not
In
better.
fact, it should go to a final hearing list. It will take a few hours, if not.
Matters be admitted. Stop. Wake up.
It be admitted.
All right.
Can be completed in the meantime. Readings can be
My lord,
completed.
All right. Whatever.
my lord, only to assist your lordship in the order your lordship has just made.
Consolidate.
Petitions have been filed, my lord.
My lord, parties were asked to file, we have filed.
All right, but.
Mr. Tripathi. If there is one issue, as you are trying to point out,
Yes, my lord.
let there be a consolidated, compilation of documents.
That is
Yes,
done, my lord,
yes.
it has been filed.
Yes.
Don't need to pass it.
Only IBC matters. Competition matters, that is what your lordships are not telling.
So therefore, please do whatever is needed.
Yes, your lordship, that's what we're proceeding.
My lord,
That's the direction that
We are not saying anything.
your lordship has said
Lord, I
all
can
the
only
matters on the
say
list.
that in
right,
some
my-
matters, notice was not issued, my lord, because of our opposition. But
No, not at all, your lordship. You tag along, your lordship, that's
No,
it.
1 minute.
it says, my
My
lord,
lord,
let
I-
that position
That's not
remain.
correct, your lordship.
It can't be, my lord, that matter is admitted by default. We are entitled to say, my lord, and that is why it was not issued in some
All
cases.
right.
Keep it at that stage.
Which is the matter where parties are distinct, that will admit. The others will just tag with the other case. That's
Your lordship already tagged, your
That's
lordship.
the
That's
IBC.
tagged.
That is tagged.
It's already tagged.
the one that is to be admitted today.
6071 of 23. No?
Those are.
My lord, I appear in that matter.
6071 of 2023.
I appear in that matter, my lord. I have only one thing to say. I always find it very odd when somebody says, don't issue notice.
Mr. Salve, you are saying something.
I find it very strange when somebody says, don't issue notice. I mean, why should somebody be heard on the other side if notice is not issued?
Because, I mean, we were saying that it should be rejected.
The word used was that there should not be admission by default.
We only ask for notice so that next time it's not adjourned, but whatever it
But
is.
it was not done. 10 times it was heard.
If it was heard 10 times, then it is worthy of notice.
In fact,
Should be at this stage.
in fact, the regulator has filed appeals, your lordships.
Now strike out everything else.
Yes.
Just शुरुआत का जो line है, this large number of appeals are listed together. They are all represented by, should we say heavyweight counsel? No. They are all, each party is represented by respective counsel. Stop. The matters be the matters be posted. We'll tell you the date. You take the date from me. All right.
Would your lordship put it on a Wednesday because it will require a Wednesday, Thursday is a better day. So,
Correct.
We'll check up the.
Yes.
so don't immediately, but then in which case is 6071 of 23, which is the lead matter, may be admitted. The others may be tagged along with it. So there's no problem. It's maintained and it'll come up on a Wednesday and a Thursday. That's a better way.
If I don't think there should be any objection to the.
Yeah, that's, yeah, fair enough. So
That can go into the final hearing.
Yes,
This
no
then.
problem.
That's right.
because if it comes on a Wednesday, Thursday, there's a realistic chance of it being heard, Manoj. Otherwise, on a
Correct.
Tuesday, it's going to be impossible.
My friend is right.
Saying, my lord, let hearings be completed in the meanwhile so that we can argue the matter the next. That's all.
Should we admit the one that?
Yes, my lord, because there are cross appeals by the regulator.
You don't have to explain. Just say yes.
Yes.
It's okay.
That matter, let it be admitted. Okay? And then we'll put it on a date.
On a Wednesday, and then the others will come up automatically on a Wednesday, Thursday.
Have that in mind. Yes.
Grateful.
Obliged.
41.
Deeply obliged.
There's some addition deletion in 43.11. Anybody is there? 43.11.
Mr. That is